In the bad old days, when people went bankrupt, they often basically were reduced to living, as they say, in a barrel. All their clothes were gone, all their assets were gone, they had no recourse under the law, and in fact, in England and a number of other locations, they actually put debtors in prison. They had debtors' prisons. Sometimes even the relatives of people that went bankrupt had to go to jail. We have revised the laws tremendously now. People are not required to wear barrels anymore, and in fact there are all sorts of protections for both individuals and businesses that are insolvent, that are unable to pay their debts as they become due. There is reorganization that is available under Chapter 11 of the Bankruptcy Code for businesses. There's also a Chapter 13 readjustment, which is permitted for individuals which are having financial difficulties but have not yet reached the point where really the only thing available is liquidation. And then there is Chapter 7 liquidation, which is what I think most people think of vis-a-vis bankruptcy, which is you are completely, basically, discharged from a number of debts. There are some debts which are non-dischargeable, and there are, of course, some types of assets which cannot be collected upon during the course of bankruptcy. It's all an area of great interest, particularly for people who, say, are examining whether a defendant is worth suing. It's not enough. There are three key things one wants in all litigation. One wants to find that there is a good cause of action that actually makes a real case against someone. Secondly, one needs to show that you have damages. It's not enough that someone did something wrong, but you have been harmed. And thirdly, and this is where bankruptcy law comes into question, you need to find a defendant who is not, as they say, judgment proof, who in fact has assets sufficient to pay all or at least some of any judgment debt that you may have entered against that defendant.
Whenever you're ready, Bob.
Well, can I start with nowadays? It's not nearly so. Okay, yeah, all right. I'll just start with nowadays. All right. Nowadays, it is not nearly so rough on people that become insolvent. Nowadays, we have laws which afford some protections for people that decide that they need to declare bankruptcy. We also, of course, have involuntary bankruptcy petitions which are available for others, creditors, who need to proceed against a person who owes them and is not willing to or perhaps able to pay on the debts as they become due. That is the definition for bankruptcy. Typically, it's not simply calculating whether your debts exceed your assets. It's looking at, as your debts become due, are you able to pay them? And if you are not, then you could well be insolvent and thus bankrupt. We have laws now that permit businesses and individuals to either readjust their income stream and their debt payments, and this is typically Chapter 11 for businesses where they can reorganize, or it is Chapter 13 for individuals who have a steady stream of income so that they can readjust their debts. Or if that really is not practical, if a business or an individual is too far gone, then typically what they have invoked is Chapter 7, which is outright liquidation. During a bankruptcy proceeding, what you have is the discharge of the debts which are in fact dischargeable. One may end up paying little or anything to particular creditors who are simply out of luck under the Bankruptcy Code. There are some debts which are non-dischargeable. For instance, child support payments are not dischargeable. And there are some assets which cannot be collected upon in order to pay for some sort of bankruptcy award. In other words, that is free from any sort of creditor's grasp. One reason this is so important is if you think about litigation, there are really three essential elements for anyone who considers bringing a lawsuit. The first element, of course, is that you actually have a good case, that you have some sort of cause of action, some legal wrong that has occurred to you. The second is that you have actually suffered damages. And the third is that there is some sort of defendant out there that is not judgment proof, that is not completely bankrupt, that actually has assets in order to pay the debt that you would be owed if you are able to obtain a judgment against that particular defendant.